I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, family? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are stepping into compilation number 68, and we're going to be in three different judges' courtrooms. One of these is going to be for a non-sovereign citizen case. So yes, this is one of those Sovereign Citizen Hall of Fames with sprinkles on top, where we have sprinkled in a non-sovereign citizen case. Before I give you the rundown on those judges, I just want to say thank you guys for all of the support for the channel, the compilations, just everything that you guys do has been amazing. We're almost coming up on a year for the channel, and I just ask you guys to keep up the great support, keep liking, sharing, subscribing, commenting down in the comment section. All that you do and that all that you have been doing thus far has been amazing, so thank you for that. Now, the judges' courtrooms that we're going to be in on today. First, we will be in the courtroom of Judge Stephanie Boyd out of the state of Texas. Second, we will be in the courtroom of Judge Marlena E. Taylor out of the state of Michigan. And last but not least, for our non-sovereign citizen case, we will be in the famous courtroom of Judge Simpson out of the state of Michigan. As always, with the compilations, no commentary added. Chapters will be added. And listen, nothing else to be said, but let's go ahead and jump into number 68.
All right, the court, and I guess this is for one case. Court is calling 2024 CR 4295 State versus Luis Beltran. Can I have parties approach and announce for the record?
Yeah, I'll wait for the Arlene Gay, the defendant.
All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand?
Mhm.
All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be, In it, it has to be allegations that it happened in Bear County. In it, it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bear County, then it would come to a felony district court, state district court that's in Bear County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have, Yes.
Excuse me, did the court take judicial notice of the indictment in this case?
yes,
Make its ruling, okay.
yes.
The
And
other,
then the next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph, that the court his position was the court didn't have jurisdiction, the court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right,
Did I get that right?
Yes.
Okay.
all right. So State, you want to address the issue and what and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right, so if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right, so Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So do you understand? You gonna have any questions about the court's ruling? All right, if there's something you don't understand, let me know, all right? And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right, so number 3, defendant is erroneously charged with an abstract offense. See, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third-party benefit in violation of the 7th Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to being a third party brought in here without abstract subject matter jurisdiction and the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right, State, do you want to respond?
Judge, regarding, I guess, the Seventh Amendment applying in the case, or, okay,
Yes.
that is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mhm. All right, so the Seventh Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm going to make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me, you're saying district court is criminally attempting to receive an unauthorized, colorable, no fault immunity? What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand? Do you have any question about that?
No, ma'am.
All right, so then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 USCS 841. This court now under federal questioning under Title 28 USC 1331. Light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm going to ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff. And they're the ones that are pursuing and to prosecute me, which is they're one of third party.
Okay.
And I'm not, I don't, third party, I'm not sure how that works. I know
Okay.
how civil suits, and I know it's criminal law, but I know that, I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bear. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would what call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bexar County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You
I
understand?
understand, Your Honor.
All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points?
Other than anything,
Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls, okay?
understood.
So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together. Is that the way it was received?
Yes.
There is the next one, which is exhausting administrative relief.
Mhm.
My client is not wanting to have that heard, right? It deals with ineffective assistance of counsel. Right, Mr. Beltran, that's not to be heard right now?
All right,
Okay,
and let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, and if Ms. Gay wasn't qualified according to the qualifications to be on the wheel for first-degree felonies, she would not have been appointed to represent you. Do you understand?
Understood.
And Ms. Gay, are you on the first-degree will?
yes, I am.
All right.
So the next document is entitled Court Constitutional Notice.
Mhm.
And that addresses antitrust violations, fraud upon the court, actions of the state bar.
All right. Do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right, the first is new discovery of antitrust violation lies, fraud upon the court, elected state bar officials, seditious organization are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the state bar of Texas lacks capacity to prosecute a natural person. It is an improper plaintiff. All right, so with that, I can tell you, the State Bar of Texas is not prosecuting you. The State Bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay state bar dues every year. And when that comes around every year, everybody's like, oh my gosh, state bar dues.
Student.
Yes. So, the state bar is not participating in this trial. Now, I can tell you as an attorney, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas, and they have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right, so they're not going to be trying you.
Yes, sir, Your Honor.
All right, the next one is state bars, virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the state bar hasn't gathered any evidence. State.
I think I just put, I'm sorry, Your Honor.
Yes.
I think I just put that as
All right, so do you want that heard or no? All right, and then the next one is, so to permanently prevent a false state bar, anything with regards to the state bar, do you still want that heard or no? It says objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901, and that, in other words, probable cause is third party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right, State, do you want to address that?
Regarding the collection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell. There are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
State, has he been tried before for this same offense?
No, Judge, there has been no actions on the indictment or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this law.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases?
No, Judge.
All right. Does that address that issue for you?
Yes, ma'am.
All right. Then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, ma'am.
All right, does that address that issue?
Yes, ma'am.
I think the other issues deal on the second page, deal with the state bar, and I think the courts address that.
Okay.
The other one is gross advertising negligence of the DA's office,
Okay.
and defendant being sued,
Oh, who's being sued?
the defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically it is sort of a suit, but it's again, the state of Texas versus whoever the defendant is. You understand?
Yes, ma'am.
All right. Do you have any questions about anything else?
Mm.
Okay. And then the next page, page 6, it has postscript. Is there something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or a corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial, okay?
Yes, ma'am.
All right. All right, is there any other motion that needs to be heard?
Anything else? Any other jurisdictional arguments that raised that we have not talked about and the judge has already ruled? Anything other than
No, no.
All right, is there anything that you don't understand about the jury trial process?
Mm.
All right, so I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes, ma'am.
All right, so if you still want a jury trial, you're, Norma, is he already scheduled for jury trial?
Not scheduled for yesterday, Judge.
All right, so, counsel, you're still requesting a jury trial? All right, Norma, if you can put them on the, jury trial, please, and Ms. Galloway, if you confer with the defense on a jury trial date, so they're gonna get a jury trial date, okay?
Thank you, ma'am.
Oh, you're welcome.
Daniel James Williams.
Yeah, I'm here on special appearance.
Okay, do you know my special appearance means what? Because I need to have the actual person present.
You need to have the actual person present.
Yes.
Person.
So are you Daniel
like,
James Williams?
I'm not a person. If you asking if I'm a person, like a legal fiction, no.
Okay. So the only person that I can have on this hearing for this person is Daniel James D'Angelo Williams. Are you that person?
Am I that person? No.
Okay. So if
Is
you
this on
know
the
them,
record?
tell them that they're going to get a show cause. No, I'm going to call it on the record, but I need the actual person because I can't communicate with just anybody. I have to communicate with this person. Did you
Is
talk
it-
to them, Attorney Werbeling?
Yeah,
Did you
for the,
talk to a Dane?
so for the record, Your Honor, or,
Okay, let me call it then. I'll call it.
well,
If
yeah,
you talk. Okay. Now calling the matter of the people versus Daniel James D'Angelo Williams. This is ticket number SP 1585809. Count 1, failed to display a valid operator's license. Count 2, no insurance misdemeanor. Count 3, 26 to 30 miles over posted speed. Appearances for the record, starting with counsel, please.
and good morning, Your Honor. Ben Werbling, P64889 on behalf of Daniel James Williams. Judge, I did attempt to talk with the individual that's on screen. He indicated that he wanted to proceed in pro per or pro se, if you will. He declined my legal services at this time.
All right. All right, sir, can you state your name for the record?
For the record, the living man, Daniel Williams.
That's good enough for me. I'll take the living man. Okay, all right. This is the date and time set in this particular matter for a, what's it called? Let me see where we at. Oh, it's a pretrial. In this particular matter, sir, what that means is that you're here today because it's been alleged that you have some tickets before my court. It's my understanding that Attorney Werbeling tried to communicate with you and you did not want his services. Is that correct, sir?
That is correct. I do not want to
Okay.
contract with Mr. Waverly.
Okay. All right. So, you have the absolute right to have an attorney. 2 of these tickets are misdemeanors. And that means that some constitutional rights kick into play because I can take away civil liberties such as up to 90 days in jail, as well as up to a $500 fine. You understand that, sir?
That's fine.
Okay. And so at this point in time, how do you wish to proceed? The 3 options are typically you can ask for some more time so that you can come into compliance. That's called a new pretrial date. You can ask for a bench trial date. That's a trial date before myself as the trier and finder of facts. The officers who wrote this ticket will have to appear in court as well on that date. You can also ask for a jury trial. That's a trial before 6 citizens of the city of Detroit who would come down here and have to decide on this matter. Or I guess it's 4 options because you can also take a plea. I think count 3 is not in the system because they had to return the ticket. So it's really just 2 misdemeanors that should be appearing on the docket for today. Let me check and make sure. That's my ticket.
Okay, I hear what you're saying, but all this sound like you're saying like go to court, and I'll go to court if appearing in person. That sounds fine.
No, we are in court right now. So my question is, how do you want to proceed? What do you want to do? What's the next step? Do you want to have a new date so you can try and come into compliance, meaning that you want to get some of these documents like your license, some car insurance? Do you want to take a plea today? There's usually an offer that's given to folks if they want to take advantage of that and take some type of resolution in this particular matter. Or you can ask for a bench trial before myself or a jury trial.
I'm trying to figure out what jurisdiction is this court being upheld in?
It's in Detroit, Michigan. That's located in the state of Michigan, the United States of America.
No. What I mean is this court in a common law jurisdiction or a criminal jurisdiction, admiralty law? But
definitely criminal. So this is a criminal matter. It's criminal misdemeanors for traffic matters.
Okay.
So that's why I told you those constitutional rights, because criminal law kicks in.
Okay, and under the criminal law, the jurisdiction of common law, it has common law and it has criminal jurisdiction, admiralty of the military tribunal review from Article 1. So I'm trying to figure out, are we under common law or the criminal jurisdiction of admiralty and military tribunal review from Article 1?
Neither. We're under criminal law in the city of Detroit, state of Michigan. That is given us power by the state of Michigan through the U.S. Constitution, as it gives powers to each state to make laws and jurisdiction and rules. And each community within that state is allowed to do so as long as it's within its powers.
Exactly. And I'm a living person, not an entity on document. I'm not an
entity in document either. I'm a living person as well. And living people get in vehicles and they drive them and they get tickets. So that's what we're here for today. How would you like to move forward, Mr. Williams? I don't have that much additional time today for it. However, I'm giving you some options so that you can be able to choose which one you want to do today. And if you don't want to participate at all, what I'll do is I'll enter a show cause. A show cause means it's a hearing where you fail to participate in my court hearing. And then if you fail to participate in the next date, then I'll issue a warrant. It's a 0 bond warrant, but it'll be a warrant out there until you want to at least choose one of these avenues. It's been allegations just at this point in time that you violated some of the laws that are followed by the citizens of the city of Detroit, county of Wayne, state of Michigan, as a part of the United States of America. It's been alleged at this point in time. So all I'm trying to do is figure out how you want to proceed today. You need some more time. You want to try and get in compliance and get that license together? I don't mind. I give time for that.
Well, I have the serial QSIB number to my license and the serial QSIB contract to my insurance as well, and it's both valid. However, they're both private. They're inside of a trust. I live privately, so I don't have to show the policy enforcers my private insurance nor my ID when they pull me over from traveling privately in my automobile.
Do you have a valid license?
I have identification to prove that I'm able to operate this automobile in my estate.
If you drove on Hubbo and Eaton That's in the city of Detroit, and that is not private property. That is
You
very
have
much a
jurisdiction
public
different from
road.
me.
That is a
But
public road that
no,
is
I
paid for
understand
by
that, but
the
you,
citizens, that is paid for by the citizens like myself who pay hefty taxes to everybody to be able to allow them to ride on those roads within the city and the state of Michigan. So if I run your license, is it going to come back valid? Because if it is, we can actually dismiss that ticket. And if you have car insurance and you show it to me today, I can actually dismiss that ticket as well. Do you got some car insurance?
yes, ma'am. I have a ongoing serial
Let me
number
see.
with
Let me see. It has to be like usually they give you a little
uh,
form. I know I have to print mine
I
out
got
from
the
mine.
I have paid for mine with FRNs online, so I only have the online document, and I have it in my Apple ID, so I could take a picture on
Okay.
this
Can
phone.
you I'm gonna send you my email address. If you could send it to my email address, that take care of two of the tickets actually. Okay, let me see. I'm gonna send you the email address.
I also have another question in settling the subject matter.
Yeah, go
Um,
ahead.
after the case get dismissed, it's with prejudice or without?
If you have the documents, I'm willing to do it with prejudice today. If you have these, you see what I just sent
Can you
you?
do it without
Send me
prejudice?
the insurance. We do it without prejudice, but they're not gonna refile it. You better
Okay.
have a valid license. His license is valid. Send me the other one. The only one that did appear on the docket is the speeding ticket. Let me see what I can do about that. That's
Speeding
the
isn't
only
a
one you might
crime
have to
though.
dispute.
But speeding isn't a crime. It has to be an injured party, and it has to be presented. And the injured party has to be having
No,
all
you
four.
talking about civil law. That's not civil law. This is like a civil infraction imposed by the state of Michigan, and the injured party is all the citizens. Essentially, if you want to go that route, because we could potentially be injured by your conduct and your behavior on the roadway.
But that I hear what you're saying. You saying the word potentially. Potentially. That's what you're saying. And then the state what somebody will have to present me a statement where the party is injured. They will have to present me
Okay.
a statement.
Well, we can always do a hearing on that ticket. But if you send me your car insurance right
Yes,
now to the
ma'am.
email address I sent it to, then I can dismiss those two counts because you got a valid license. And if you got valid insurance, did I send it to the right person? Or I put it in the chat for everyone. I'm gonna send it directly to you, Mr. Williams, okay?
Yes, ma'am.
Okay. Because if you can send me this, okay.
Mr. Watts, I'm sorry to interrupt the meeting.
No, you good. He's in here and he's
Mr.
not
Watts, I need
connected
to.
to.
No,
Go
he's not.
ahead.
I'm gonna just call him on his phone.
Okay, that works.
I have another question.
Yes,
There'll be
sir.
no spot on my savings bonds, will there?
No, there won't. I'm just strictly dealing with these matters. You have a really nice, clean record. We can dismiss at least two of the tickets. I know you have some disputes about the last one, but just send me the other one because he has a valid license. Go ahead, Mr. Williams.
Appreciate you.
No problem.
Let's
We're
see
gonna get
this.
through this.
I'm trying to write it down because I can't really see.
Mhm. Take your time, just do it. I'm sitting right here waiting. Okay.
And that's .com? Oh, .org. I see it.
.org. I'm sorry. You see it? Attorney Werberling, we're off the record in this other matter. I'm gonna see if Mr. Wright will answer and come back to the courtroom. He did. Mr. Wright. Charles Wright. Mr. Charles Wright, press *6 on your phone. Or unmute yourself.
I don't know if he's even muted, Judge.
He is already unmuted. Charles Wright, I'm gonna just remove him. Maybe he'll log back on or something. Because that was your last person, wasn't it, Attorney Werberling, I think?
I believe so, Your Honor.
I'll give him 5 more minutes to sign back on. If he doesn't, then you are free if you would like to. I know we had a long week with a lot of members of our wonderful community coming in. So.
Thank you, Judge. I'll be here.
Okay. All right. Wait, let's see if he logs back on. Maybe he was having trouble hearing us. Attorney Mason?
Yes, Your Honor.
All right. The only ticket, and I'm just waiting for his
SOS.
His SOS came back valid for his license, Mr. Williams. Cool. He has a valid license. He's in it over the insurance. It's the speeding ticket that he's disputing at this point in time. I could set it for it's 26 to 31. He was doing it was a stationary radar 51 and a 25 alleged.
Is this your award?
This is Daniel Williams.
51 and a 35.
25, unfortunately. It looks like he was on a Hubble and Eaton. I'm sorry, I should enunciate my words, as my dad would say.
What's his record looking like, Judge?
This is it. His record is totally clean. And he does not have a CDL. This is he don't have nothing on it but his name at the top of the sheet of paper.
Okay, you know what? Okay, Mr. Williams, don't do it again, okay, please? Don't do it again. Please.
I won't. I won't.
I mean, we worry about little kids and little old people like me.
Yeah.
You know.
No, I'm part of it. Like I know y'all see the crystal. I'm real, like, you know, so it was a rough day. That's
okay.
All.
Okay, I'll give Judge, I'll leave it to the court's discretion. There we go. Whatever the judge wants to do.
Mr. Williams, when I get this little insurance, if your insurance is good, I'm gonna dismiss all 3 counts today. Look at you when you participate actively in our system.
I sent it. I just sent it to you as well.
I know. I'm just waiting for it to come through. I was excited when I saw that you had a valid license. Tell your friends, please, to do what they do and get their license, because it's not that hard. And look at you. You're gonna keep a clean record today. You see that, Mr. Williams? By coming on here, I know you want to stay your ground, and I understand. As part of growing up is learning to exercise your stuff, but it's also being respectful, and you were respectful. And look what happens when you're respectful.
Yes, ma'am. I appreciate that too.
Okay. All right. Sometimes it moves a little slowly, so don't feel bad.
You know, Judge, usually I dismiss the insurances myself. I always dismiss those insurances, so you know.
Okay. Yeah. I was about to say, right now he's floored me with this license after he came on here talking about the person of. So I'm excited.
Yeah, I've been doing my research since I was like 18.
Yeah, don't stop that research. You just do what you did. Act respectful. Come in here. Allow counsel to help you next time, because they're not trying to lead you down a path. And you keep that license up to date, valid. Keep your insurance up to date and valid in your vehicle, and slow down. You won't have no issues. Back on the record in the matter of People versus Daniel James D'Angelo Williams. This is ticket SP 1585809. I caught this matter already. We had to stop and get some information. Just state your name once again for the record, Mr. Williams. Please say your name.
Daniel Williams, the living man.
All right. It's my discovery that he has a valid license. We have had a nice little talk about him showing documents. He has insurance. And on the speeding, we're gonna give you your break, right? But if you come back again, we'll be able to see it. So just make sure you keep everything valid, up to date, and slow down. I'm going to dismiss these tickets today. And I'll do them with prejudice in your honor, okay? All right, if there's nothing further, Mr. Williams, you're all set. Thank you, and keep that light going, okay? Don't let them kill your light.
You have a peaceful day.
You too, thank you. All right, you can log off, sir.
Courthouse case, People versus Larry Lee.
Your Honor, Mary Tanha, Assistant Prosecuting Attorney, about the people.
And Mary Rubio, on behalf of Mr. Lee, I am standing in for the attorney of record, David Burgess, with Mr. Lee's consent, to my knowledge. Is that correct, sir? That is okay for me to stand in for you right now?
Yes.
Okay, could you please state your name?
Thoroughly.
What is that noise?
Right. Shouldn't you check? I don't feel safe. Why are you just pointing? What?
Don't stop.
It'll stop at some point.
I feel very safe, Your Honor.
Wow, I know. He's like, you are all over it. All right. Yes. All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Quasny. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange, there's a pending case where Mr. Quasny is the defendant of an AMV against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Quasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Quasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge, because we want it documented for potential additional charges. But this all transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
But does that recording indicate that?
Yes, Your Honor, have either one.
Okay. I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicates he indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But just so that I have this right, the defendant, because of something else, is urging, enticing, or in some other way interfering with testimony of witnesses in this case.
I can't agree to that characterization because I haven't heard it. I don't know.
Well, you want to listen to, because that's what I'm being told.
But yes, I understand. I understand that is what's being presented. I also want to indicate that. Go ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge, I indicated to, what's her name?
Mary Rubio, Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Quasny, and I instructed him to offer a plea or to negotiate some sort of settlement. And he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be. And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated that he had not heard anything and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he.
I don't know. Are you a lawyer?
I was.
Mr. Lee, no. To my knowledge, no.
So I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself. And I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorneys. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry to interrupt Mr. Lee before he makes more statements.
And I did record the. I recorded the call.
Criminalizing himself.
I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication there's no discussion of a plea. Not what was sent to me. That was recorded by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Consley agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text messages.
I want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, right? Has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right. Okay. I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that.
And so I'm gonna give an opportunity for the defense to give me some explanation, but I'm inclined at this point, I'm gonna hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay.
Okay.
All right.
Thank you.
Thank you. Can we get Mr. Lee out? No, oh, is he? Okay, great. Court does call the case of the people versus Larry Lee.
Good afternoon, Your Honor. Marina E, Assistant Prosecuting Attorney on behalf of the people.
I forgot to wear a second.
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom.
I'm sorry?
Mr. Rubio. Oh, there you are.
Good afternoon, Your Honor. May it please this honorable court, Joseph Arabo on behalf of Stephen Quasney.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Arabo sent me, as well as Mr. Burgess and law enforcement as this morning.
All right. And that portion of the phone call, as the court is to understand, is basically this defendant speaking with, is it directly with the victim in this case?
No.
No,
An attorney.
It's with Mr. Arabo, who's attorney for the victim.
All right, and basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
That is how I would characterize it, Your Honor. If Mr. Arabo has additional information or different information, he's welcome to.
Yes, Mr. Arabo.
Yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me, and then once I realized what this was, which is an attempt to extort and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time. I was quick enough to get on my computer and record it so that the court is aware of what's going on in the matter where I represent Mr. Kwasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length about the purpose of the phone call. I also listened to the portion of the phone call. Perhaps the court could listen to it. I do not believe that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me is that he and Mr. Burgess have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what he has called, not being a lawyer, using the words a settlement agreement or a plea negotiation. That's what he said to me. And that he had the feeling that Mr. Burgess had not, in fact, made this phone call. So he then called this attorney, and right in the phone call,
because it would have been unethical for Mr. Burgess to call to try to say my client won't testify in this other matter.
Of course.
If that, right? That's what Mr. Burgess may not have done.
And that may very well be. But Mr. Lee indicates that, and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
That would be irrelevant.
I know that. Judge, trust me, I know that. But I just wanted to make a record. What, can I just finish though?
Let her finish.
Mr. Lee indicated the main purpose of the phone call was for him to find out whether this attorney could verify whether Mr. Burgess called him. If you listen to the call, the portion of this call, it's literally on there. He says, it starts out with him saying something about plea agreements. It's the call, it's interrupted. And I believe because counsel didn't realize he was going to need to record this. But anyway, it starts out with him, Mr. Lee, saying something about plea agreement, settlement agreement. Was there any, did Mr. Burgess call you to try to, see if I wouldn't testify and then your client wouldn't testify? Yes, he says that. But then he goes on to say, because my lawyer said he called you, and then this attorney confirms what Mr. Lee was trying to find out. And this attorney says, no. You see how easy it was to reach me. I didn't talk to anybody named Burgess. That's what he says. So I'm just indicating that Mr. Lee states that was the main purpose of his call, because he claims he wanted to come in here today and tell Your Honor that he did not want to have Mr. Burgess represent him anymore because he feels Mr. Burgess is lying to him. I'm just representing to you what Mr. Lee has told me.
Your Honor, if I may.
I'd like to say something.
Thank you. Mr. Arabo, it's my turn. One moment. Your Honor.
Because apparently that's how it works in this courtroom. Tana says it's her turn, so it's her turn. Go ahead, Miss Tana.
Mr. Arabo had some trouble with the drum.
That's only because she's there and I'm not.
Your Honor, I don't really, quite frankly, care what's going on with the client relationship with Mr. Burgess or claims Mr. Arabo is making about extortion. That's not something that people are going to get involved in at this stage. What I'm concerned about is there is a clear difference between a plea negotiation and two witnesses not testifying, one of them being Mr. Lee, the other one being Mr. Crosby, not testifying in exchange for something. And I agree that the court should just listen to the call rather than us going around calling it different things. What's clear to me is that there is an offer to not testify in exchange for Mr. Crosby not testifying in this case before this court. That is what I'm hearing on that call. That is what's concerning to people, and that's what may bring future charges. We're in an early stages. This needs to go to law enforcement. If it has gone to law enforcement now, and we can follow up.
Mr. Rubble.
Your Honor, as you know, I'm a defense attorney. I think it's Ms. Rubio is really grasping at straws here to try to help her client. But here's what it is. It's not a plea. We heard her say plea. A plea means a reduction to something other than what is being charged with, not a dismissal, which is clearly being indicated in this. Second, what's happened here is you could see clearly there has been a subsequent case filed. I don't know how this slipped between the cracks because in over 10 years of practicing, I've never seen something like this where a victim turns into a defendant. What during a pending case? Never seen anything like this. So Mr. Lee has done this intentionally so that he can one day use it as leverage to contact me or have somebody else contact me or whoever is representing Mr. Kwasny so that he could use it as a negotiation tactic. And what he's engaged in is third-party communication to get through to Mr. Kwasny in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion. Let's find something else. It is witness tampering. He's trying to tamper with Mr. Kwasny using the leverage that he created. And I don't know how the prosecutor's office allowed this to happen. Somebody wasn't monitoring things properly, but this is what's happened. First ever time I've ever seen anything like this. And it needs to be handled. It needs to be handled. It's going to be handled.
Okay.
Can we listen to the call?
Everybody
Yes,
listen to it already.
Can somebody send it to Ms. Weidling and I will then be more than happy to listen, or if there's an easier way for me to do it, I'll do it. Let's take the defendant back and court to listen to the call. I can give my decision.
You have to go back.
To you. Court does recall the case of the People's State of Michigan versus Larry Lee.
Good afternoon, Your Honor. Marie Tan, Assistant Prosecuting Attorney. I'm about people.
And Mary Rubio on behalf of Mr. Lee, who is approaching.
Get your name, please.
Larry Lee.
Okay. The issue is in this case that, first of all, we're adjourning the hearing over.
I believe we are. That was what I thought we were doing in the beginning.
Well, it's got to stay before me. So.
I know Mr. Burgess is already going to be here on July 1st. I just wanted to put that out there.
Yes, but I'm not on the.
Oh.
I'm on the bench, but I'm not doing these.
Okay.
So. Set his preliminary examination July to defendant's request. So my next date is July 22nd, 2025, and that's another 12 p.m. start because God, I love that. All right. With reference to bond in this case, I've listened to the recording. I'm not going to say there's an over exaggeration or an under exaggeration. I mean, I think it's relatively clear when somebody very clearly points out an exchange or quid pro quo regarding me not testifying and this other person not testifying, and that is the exchange. I don't know that you get a clearer indication of somebody that is attempting, and especially when they circumvent their attorney, of somebody trying to sort of tamper with and obstruct a case. It couldn't be clearer. I mean, and quite frankly, I don't think there's any design to necessarily frost it over or anything along those lines. I think the idea or what Mr. Lee is saying about what Mr. Burgess wouldn't do is quite frankly just a ruse to hide his own desire to have the exchange that he was speaking with counsel about. Given that, and the court having heard that, with reference to this case, the defendant's bond is hereby ordered revoked based upon the court's hearing of that bond violation.
Your Honor, can I just raise two issues? Before all of this happened, Mr. Lee expressed to me and attempted to express to the court his, as I'm sure the court has gleaned, his displeasure with Mr. Burgess. So I do think there, given some of Mr. Lee's allegations against Mr. Burgess, it may be best if someone else is appointed to the case. I know he doesn't want Mr. Burgess.
And that's fine. I don't know whether or not he doesn't want Mr. Burgess or not, because I think, as I'm indicating, I think that notion of Mr. Burgess not doing something and then his checking is simply a ruse for him to try to get the message that I want this quid pro quo, this exchange.
And I'm not accusing Mr. Burgess of anything. I'm just trying to represent what Mr. Lee has told
And I
me.
understand that.
And Mr. Lee is
I think
about
when
jumping out of his skin trying to talk, just so you know.
And so when you talk to Mr. Burgess, if Mr. Burgess, if he believes that that's the appropriate step, he can bring that motion before this court and the court will hear it in the day that I'm on. Mr. Lee, I will let you talk in a moment, but I'm going to finish this. Revoking your bond because of what is a clear violation of the bond regarding, I mean, I think it's an attempt to try to get indirect contact as well as obstruct these proceedings. Because that was accomplished in the manner it was, and I'm not sure that I can trust you with reference to no context and the like, we're at least going to get through this. I am going to, subject to a hearing, defendant's phone privileges for the jail are also revoked. What did you wish to say, sir?
The thing that my substitute attorney here didn't convey to you was that I told her that I have the evidence with me in hand, that my attorney, Mr. Burgess, was the one that actually said that this was a legal way that we can go about it. And no, I'm not.
You know what, Mr. Lee, you might as well stop right now.
I have the text
because
message.
no, I'm going to tell you, I don't know if you're misunderstanding something or what, but you are not. Mr. Burgess has appeared before this court. You are not going to sit here and try to disparage that man, saying that somehow or another, Mr. Burgess represented to you that obstructing a case in this fashion was a legal way to proceed. I'm not going to believe it, and I'm not going to hear you. I'm not going to hear you. I don't know what you, how do you not understand what I'm telling you? Now, if you've got that information and you think that's what it says, you get it to counsel and the court will take a look at it. But you're not going to sit here and disparage that man. It is not going to happen. I'm done. Bond revoked. Take you.
Thank you, Your Honor.
I'm not threatening you. Say one more word and that's 30 days. 30 days.